All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So, Phil, we've got several topics today. We're going to do a couple bonus topics today on Lawyer on the Clock segment. So the first one, I always just find stuff like this entertaining, is that a little over a week ago, the Department of Justice in Washington, D.C., their civil rights lawyers at the Department of Justice are trying to form their own union amid an uncertain future. And that uncertain future is the presidential election. So the lawyers in the Justice Department's Civil Rights Division have launched a union organizing campaign with a really aggressive timeline to try to secure bargaining status ahead of the next presidential administration. They're attempting to form what would be the Department of Justice's first known union of litigators. And that's parallel to a more advanced effort inside the department's environmental division. And it's focused on maintaining stable working conditions such as telework flexibility in the face of an uncertain future. The employee organizers are also trying to overcome, quote unquote, a widespread misunderstanding among civil rights division lawyers that they're ineligible to unionize, according to materials disseminated to the staff in late July. So they're trying to tell people they are eligible to organize. So that's going to be a fight that they're going to have. And the organizing committee is aiming to hold a representation election by October 2024. So just a couple months from now,
they're hoping to have a vote right before the election. Yeah,
that's exactly right. And you can definitely connect this to the presidential election and the rank and file lawyers at the Department of Justice. They're concerned that with the new presidential administration, they want to have a union so that they could try to preserve their jobs.
Okay. Have you experienced attorneys organizing before any time, or is this something that's happened, or there's been an attempt?
I have never seen this before. Yeah, I've
No.
never seen this before anywhere. And it'll be really interesting. I mean, clearly when the Department of Justice Civil Rights Division circulated material telling people they're ineligible to unionize, probably gets to that point, and they're trying to tell people that they are eligible to unionize.
Well, this is going to be an interesting one to keep our eye on. I got no skin in the game, but I'm very interested to see what happens. You, however, my friend, have skin in the game, because I can't imagine this going through the Ogletree files and systems of, hey, let's get together and get our union organizing meeting going on and see you carrying a banner there, Bert. I just don't see it.
Not going to happen.
Yeah. All right. What else you got?
The next one I thought was kind of interesting. Here in the state of Missouri, our university, our largest university here in Missouri, Mizzou, is eliminating its DE&I division, the entire division. Really kind of an interesting move, and we've talked a lot about this in weeks past about sort of the trend in business. And the Vice Chancellor for Inclusion, Diversity, and Equity, Maurice Gibson, is departing to take a role at a historically Black college and university in Arkansas. And his entire department is going to be disbanded, and staff is going to be moved to different departments. And the president of the university, Moon Choi, basically stated, as a university, we receive about $500 million per year in appropriations and $200 million in capital one-time projects. And if we don't receive the $700 million per year, we would have to eliminate every single position in all of the colleges that we have at the University of Missouri. That's not a risk I want to take. I want to have a good relationship with the supporters of our university, and our biggest supporters are the taxpayers, and by proxy, they're the elected officials that represent them. And they say that they would have made these changes anyway, even without some of the political pressure. But it is interesting to see that Mizzou is dropping its DE&I division, especially when Mizzou was sort of on the forefront of some of these efforts early on.
Yeah, that was big news when I heard that, and I think the taxpayers in Missouri, of course, I'm from Missouri, so a little bit closer to that than I would be if it was in another state, another place. And you've always talked about the pendulum swings a little bit, back and forth, and that will come back around. I think that's what we're seeing here. I think they went a little too far. You've been keeping us up to date on, the ins and outs, if you will, of what we should do and having goals, and when do we actually go too far and break the law by establishing some of these goals. I'm not suggesting Mizzou has done that, but you're definitely hearing the tax base say, hey, I think you're going too far.
Yeah, I would agree with that. On a more interesting case, in my opinion, last week, the Ninth Circuit, that means the court all the way out in California, in some of the Western states, they issued a unanimous decision that I think is going to impact a lot of people, a lot of harassment cases. And in that 38-page decision, they essentially reinstated a former federal prison psychologist lawsuit that had been dismissed at the trial level. And the lawsuit was over a now defunct Instagram page run by a corrections lieutenant. And the account was allegedly replete with offensive memes, both directed at the medical professionals and others. So, and Phil, you might be asking yourself, well, what does that mean, offensive memes? Well, apparently on this Instagram page, there were memes about raping this particular corrections psychologist on there when she planned to host a party at her home, which she canceled after viewing the post, as well as several others posts that mocked her for lodging complaints about the harassment. Apparently, the supervisor also used memes to ridicule women's bodies after giving birth, with several specifically addressing breastfeeding that had vulgar imagery attached to each one. And according to case filings, dozens of coworkers, including higher-ups, followed the page, with some liking and commenting on the posts and some discussing them positively in the actual workplace. So why am I talking about this case, Phil? Because the court here basically said that the judges rejected the idea that only conduct that occurs inside the physical workplace can be actionable. And they said particularly here, because of the ubiquity of social media and the ready use of it to harass and bully both inside and outside of the physical workplace, that this conduct that occurred outside of work was enough to support a claim of harassment inside the workplace. So
and this was not a work Instagram page. This was a private Instagram.
Correct, but a lot of people from work were on this page, and so I think this serves as a warning to employers. Phil, I know you and I've talked about this in the past, and my advice always, especially when you have supervisors involved, is that supervisors really should not be connected to or friends with or following their subordinate employees on social media. It's just a bad idea.
Yeah, it is. And actually, this is something just as an FYI to you and all of our listeners, and some of the advice that we've gotten from yourself there, Bert, is at least once a year, I have this conversation with all of our employees about their personal interest and social media activity. And basically what I'm really encouraging is for people not to follow each other and participate in each other's social media activity just for reasons like this. It goes bad, whether it's purposeful, mean, unintended, intended to be funny, whatever, it goes bad. And as employers, we're stuck having to manage that. And it's never easy. And often we don't know about it if we're not involved in it.
Well, and the other thing is sometimes when you're friends with subordinate employees on social media, you learn things about their religion, disability, other protected characteristics. And once you know that, even though you learn it in a non-work setting, you know it. And so, you
can't unknow it, can you?
Right. You can't unknow it. And so, you don't want to put yourself in a position of being accused of discriminating against somebody because of what you learned about that person on social media.
Yeah, absolutely. No, that's a close one. And I know when we've done programs in the past, we get tons of questions about social media. Maybe we can do a deep dive on that on an episode coming up because that's always of particular interest. All
Yeah,
right,
that
there, lawyer on the
sounds
clock.
good.
What else you have for us?
All right,
Anything
I'm
else?
gonna keep going. Yeah, we got a couple other little interesting ones. One of them will be a really quick hitter. A group of Democrat lawmakers last week introduced a bill that would overhaul civil rights law and eliminate the tipped minimum wage. Think about restaurants. This new act is called the Bringing an End to Harassment by Enhancing Accountability and Rejecting Discrimination in the Workplace Act. In other words, Bill, it could be called the Be Heard Act. And it would do several things. So right now, Title VII only applies to employers with 15 or more employees and has a 180-day statute of limitations that under certain circumstances can extend to 300 days. What this would do is it would extend civil rights protections to all employees. So if you're an employer with one or more employees, it would expand that. It would include independent contractors and interns and extend that limit for reporting harassment. It would also do away or bar with mandatory arbitration and pre-employment non-disclosure agreements for all allegations of discrimination, and that would build on laws passed in 2022 that outlawed forced arbitration and non-disclosure agreements for sexual harassment. The proposed legislation, like I said, would give workers more time to report harassment. And significantly, this new law would eliminate the damage caps on compensatory and punitive damages under the federal civil rights laws. And again, they've also snuck in there eliminating the $2.13 tip minimum wage credit that restaurants can take advantage of. So what I see this bill as is sort of a wish list of the Democrats on what they would like to have passed in civil rights legislation. It's not going to pass before the election, but it does sort of telegraph what you could expect to see if Kamala Harris wins the election in November. And if she doesn't win the election in November, you could expect to see the Democrats trying to push these types of policies.
All right. I know you got one more.
One more. And I just wanted to follow up real quickly. There was a really interesting article floating around on the internet. It was an interview or an article written by the Papa John's founder, John Schneider. And the title of it really builds on what we talked about last week and probably segues pretty good into Mikey Mack's talk today about
almost like we planned it.
Yep, it's almost like we planned it. And the title is The Troubling Future for Fast Food Franchisees. And basically in here, in the article, he says between rising prices, tax increases, and minimum wage hikes, the entire fast food industry, including pizza delivery, is at an inflection point. What happens next will determine the type of food future generations of Americans enjoy, how much we spend on dining out, what our cities and suburbs look like, and what sort of culture we export to the rest of the world. He cites some examples of formerly prolific chains that have fallen into obscurity, like Bob Evans, Long John Silver's, Godfather's Pizza, and Checkers and Rallies. And basically, at the end of the day, what he's saying here is that fast food has always been known as a quick, easy, and above all, affordable way for middle-class families to enjoy a meal. In recent years, the fast food prices have begun outpacing wage gains for working Americans. As a result, news outlets are filled with stories about disgruntled customers complaining about the skyrocketing prices of seemingly fast food. And then he references that study we talked about last week, where he says this is conceptually becoming even more difficult in some places like California, when Governor Gavin Newsom signed a law that raised the minimum wage for fast food workers to $20 per hour. Before the law even took effect, fast food companies in that state cut 10,000 jobs, with thousands more job losses coming in the first month after the new minimum wage took effect. So again, just kind of builds on what we talked about last week, that I think there are some unintended consequences, but you have to wonder that we could sort of see this coming in advance of the new law. And so it does make me kind of question, maybe these are intended consequences. I'm just not quite sure. But the bottom line is when you start putting this kind of wage pressure on the lowest paying jobs in the economy, and that creates some compression. And I think that's the idea. They want to compress wages. They want those low jobs to be higher paying, and that forces everything else above it up. And but one of the consequences is that business will adjust, and at some point they're going to go out of business, which I think is the point of his article.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.